Chapter 33 Provision as to Bail and Bond, Section 436 to 450. In a bailable offence, the bail is granted as a matter of right in police officer by court. In a bailable offence, the bail is granted as a matter of right both by the police officer and the court. In the bailable offence, no condition can be imposed while granting a bail by a police officer or a court. For the purpose of Section 436 of CRPC, a person arrested shall be presumed to be indigent person if the person is unable to give bail within 1 week of his arrest. In a bailable offence, no condition can be imposed while granting the bail by police officer or by court. Section 436 of CRPC provides for granting a bail to an accused pending a trial if he has undergone from 1/2 period of imprisonment specified the offence for which is being tried. In the case of non-bailable offence under Section 437 of CRPC, the magistrate can release a person produced before him on bail if the offence is punishable with imprisonment up to 10 years, if the person does not appear to be guilty of offence punishable with death, imprisonment for life, or if the person is not previously convicted of any cognizable offence punishable with death or imprisonment for life, imprisonment for 7 years or more. A metropolitan magistrate may release an accused on bail in non-bailable offence except in the following cases: if there is a reasonable ground for believing that he has been guilty of an offence punishable with death or imprisonment for life, there is a reasonable ground for believing that he has a guilty of cognizable offence and he has been previously convicted of an offence punishable with imprisonment for 7 years, he had been previously convicted for 2 or more occasions of cognizable offence punishable with imprisonment for 3 years. Consider the following statement. A court has no power to release a woman on bail if the offence accused shall not be released on bail by the court if he had been convicted previously on 2 or more occasions in cognizable offence punishable with imprisonment for a term of 3 or more years. Necessity of identification by witnesses during investigation not be sufficient ground of rejection of bail. Under which section of CRPC a police officer can release an accused on bail in non-bailable cases? 437. Anticipatory bail can be granted to a person apprehending of arrest on accusation of having committed a non-bailable offences under Section 438 of CRPC. Section 438 of CRPC can be invoked in the case of non-bailable offence. Anticipatory bail under Section 438 of CRPC is granted by Court of Session or High Court. Anticipatory bail implies the direction of the Session Court or High Court to police officer to release on bail an accused alleged to have committed a non-cognizable offence in event of his arrest for a term and condition which the court considered to be proper case, for which one of the following offence under CRPC 1973 application of an anticipatory bail of Section 438 can be moved. Non-bailable offence. Bail to a person apprehending of arrest can be granted by High Court or Court of Session. One, on the application made by a person apprehending of arrest on the accusation of having committed a non-bailable offence of the High Court and Court of Session may under section 438 of CRPC give the direction that in the event of such arrest he shall release on bail. Application for anticipatory bail may be made before High Court, Court of Session. Jurisdiction to grant a bail under section 438 of CRPC vests with either High Court or Court of Session. Provision regarding anticipatory bail is given in the Code of Criminal Procedure under section 438. Jurisdiction to grant a bail under section 438 of CRPC is vested with the Court of Session and the High Court and not in the Court of Magistrate. Anticipatory bail may be granted, not correct. C. Subject to the limitation imposed on 437 on make special cases where the case has been registered against the petitioner. Anticipatory bail under section 438 of CRPC means direction to release a person on bail issue even before a person is arrested or apprehension of arrest. Anticipatory bail under section 438 of CRPC may be granted by High Court and Court of Session. Which court will grant the anticipatory bail under section 438 of CRPC? Court of Session and High Court. Can anticipatory bail be granted in respect of bailable offence, and if so, in what circumstances? Anticipatory bail cannot be granted in bailable offence. Under power to grant anticipatory bail, section 438 of CRPC vests with both the Court of Session and the High Court. Anticipatory bail implies directions by Court of Sessions and High Court to the police officer to release on bail an accused alleging to have committed a non-bailable offence in the event of his arrest on the term and condition which the court considered proper in the case. Which one of the following cases related to anticipatory bail? Dinesh Dalmia versus CBI. Application for anticipatory bail may be filed High Court and Court of Session. Which section of CRPC does not apply the provision of committing an offence under Scheduled Caste and Scheduled Tribe Prevention of Atrocity Act 1989? 438. Anticipatory bail may be granted by the Session Court and High Court. Which one of the following cases is related to anticipatory bail? Joginder alias Chinda versus State of Haryana. Jurisdiction to release an accused on anticipatory bail is not with Chief Judicial Magistrate. In which one of the following cases the Supreme Court laid down the principle granting anticipatory bail? Guru Baksh Singh versus State of Punjab. Guru Baksh Singh Saiba versus State of Punjab. Saluddin Abdul Salmad Sheikh versus State of Maharashtra. Sridhi Ram Satyalingappa Mehtra versus State of Maharashtra. Sunita Devi versus State of Bihar. The bail granted to the person who is apprehending the arrest called anticipatory bail. Pre-arrested bail granted under 438 of CRPC. Filing of FIR is a condition precedent to exercise the power under section 438 of CRPC. The statement is false. Under which section CRPC bail in anticipation of arrest is filed? 438. Order granting anticipatory bail became operative on arrest. Whether any condition imposed by the magistrate when releasing any person on bail can be set aside or modified. If yes, by whom, under which provision? High Court or Court of Session under Section 439. Which one of the following court can set aside or modify the condition imposed by the magistrate whether granting a bail? High Court or Court of Session under Section 439. In the case of the state wanted to apply cancellation of bail of accused, as per the decision of Supreme Court of India in the case of Delhi administration versus Sanjay Gandhi, which one of the following may be appropriate ground for seeking cancellation of bail of arrest? That the court granting the bail had not taken into account of fact that non-cooperation of accused in investigation during a period of year to grant the bail. Under Section 439 of CRPC, jurisdiction to cancel the bail vests with Court of Session or High Court. Bail amount fixed by magistrate can be reduced by High Court and Court of Session. A person arrested and remanded to judicial custody for offense of theft. He is in such custody for last 3.5 years and his trial has not been commenced. Which one of the following suggestion is correct? He shall release on bail only where he remain in custody for half of the maximum period of sentence provided for the offense. Any condition imposing the magistrate when the releasing any person on bail can be modified by Court of Session and High Court, who may cancel the bail given under Section 436 of the subordinated court. High Court and Court of Session. General rule relating to the fixation the amount of the bond under the provision of bail and bond in CRPC that it should not be excessive. Penalty under the security bond can be remitted in full or in part. Cash in lieu of security bond can be permitted with 445. An order passed by magistrate under Section 446 of CRPC is applicable to session judge. Which one of the following provision of CRPC is not related to appeal? 450. Bail, not jail, is general rule billable offense in India. Personal liberty must be cherished right of human being. The liberty of security under security bond is mutual exclusive and liberty of the accused under the personal bond limited to amount of security of bond. The term bail signify condition release of an accused arrested person by police, magistrate or court during the investigation or trial. Under Section 439 CRPC, jurisdiction to cancel the bail vests with Court of Session and High Court. Which one of the following is not correct regarding provision of bail in case of non-bailable offense? Bail cannot be granted to any accused who may be required being identified by witness during investigation.